Greetings, everybody. Welcome, welcome to thctrust.org. This is Sylvester Moore Eel. Today we're going to continue where we left off in this just long string of series of videos. This is where we're going to go. We're going to continue with the theme of discharge. In this video, we're going to look at what a discharge actually looks like. I guess you can say when it's completed or when it's done. That's not to necessarily say that because you have evidence of the discharge and that it is complete, that you still are not going to have to enforce it. It's just like getting a judgment for money, right? You say you get a judgment order, somebody owes you $20,000. That is the judgment. It doesn't necessarily mean that it still doesn't need to be enforced. It may or may not need to be enforced. They may get the judgment against them and write you a check. Or you may have a judgment order and have to go through separate procedures to enforce the order. But the idea is to expect, the expectation is if you have the order, that's the proof and the evidence. So everything else is just enforcement. That being said, make sure you like and subscribe to the video if you enjoy the content. Create a membership on the website or below this video, and you can also click the links below this video to establish a coaching session. And I've opened up the THC conference room to all the listeners, so you can also click the menu below this video to join the THC Trust conference group. And it's on Telegram. So let's go to the website, thctrust.org. Log in if you don't already have an account. Click down here to create an account, and this content is going to be under discharging debt, discharging obligation. It's going to be at the bottom down here. That's where I'm going to post this information. And now we're going to go what the actual discharge looks like. Now when I go through this video, I'm going to go back here under the personal status correction menu right here under advanced topics. And part of the purpose of this video is I want to go through different aspects of the personal status correction menu, which is kind of like a prerequisite, right? Because I believe to put yourself in the best position to have all the tools that you need to discharge the debt, you have to be a secured party creditor and have your master discharging and indemnity bond, or some people call it private registered set-off bond, on file with the Secretary of the Treasury of the United States Treasury. This is the account or the bond held in the Treasury that you will use to write your banker's acceptances or to draft your instruments off of. So the reason I'm going to again be cross-referencing things under the personal status correction menu is because I want you to better understand, especially those who are setting up their trust, doing their UCC filings. When you see me do different things, why we apply for a tax ID number like this, why we trademark the name. When I cross-reference this in other areas, you'll see, oh, that's why we set that up in personal status correction. That's why we got the private address. This is why we got the private banker and trustee's tax ID number. This is why we set up our trust like this. So not only are you going to see this as we go through this discharge debt video, you'll see it in just other various parts of the site. So that's what we're going to be doing here. We already really seen all of these instruments, but so we're only going to point out some of the things in the instruments. If you follow along on the left hand side of the screen here, and by the way, none of this is legal advice, ideas, thoughts, concepts, just sharing these things. And this is not a misrepresentation that if you join our website and you follow these templates that you are going to have success discharging debt or anything like that. It's not a misrepresentation of that. This is just sharing research and templates to those who understand what to do with them. Now, if you look on the left side of the website, this document that we're going to go over here, the actual discharge, we see 1, 2, 3, 4, 5, 6 documents that we're going to basically take a look at here. And I would say these are the actual discharge. So we talked about the notary protest. the notary being the one, or the notary presentment first, the notary presenting your instrument or your draft to the person who's supposed to receive it and enforce it. So what we see here, so here's the notary protest, here's the actual banker's draft, the actual instrument on the screen, and then after that you have a 1099 INT, which from my research, a 1099 INT is what you would issue when you give someone a payment over $600. It's interest income, and on this form you can see the IRS is tracking the payer, and the IRS is tracking the recipient of the payment. So these three documents, the first three in this group of 5 or 6 or whatever it was, actually it's the first 4, the notary presentment letter, the actual banker's draft, the recipient copy of the 1099 INT, because the original goes to the IRS. And the last one is just an example of their payoff statement, where you will probably write an accepted for value or banker's acceptance across the face of it, or maybe on the back of it. But basically this payoff statement, or the evidence of debt of what you're discharging, should make its way in this package so it can be there attached to or behind your draft. And those will be the only 4 first documents. That's the first transaction, right? The same time, if it's possible, the same time you present the instrument through the notary as a banker's draft, include the recipient copy of the 1099B in there. Based off of my research, what I've read is when the IRS receives this 1099B, they're going to be tracking and expecting to see the income ledgered in the recipient's tax return. So you're kind of forcing the issue in this transaction. But when you think about it on a very basic level, the first transaction is centered in the banker's acceptance. You capture that part of the transaction by filing the 1099 INT. Let's see if we can zoom in here on it. I'll make it bigger. Right? Now, because this is a payment, payer, recipient, the amount, and now they're tracking it. So let me point out something else real quick, and let's go through some of the cross-referencing that I want to do. In this cover letter, we see it comes from the notary, which is the presentment, and it goes to ABC LLC, or whether the company that we're sending the banker's acceptance to. Dear Mr. Anderson, who would represent the CFO, this is the notary talking. I have been contacted by Sylvester Moore Eel, trustee for SDM Private Bank and Trust, attorney in fact for Sylvester Dylan Moore. Let me break that down. That's like a trust registration statement, right? But what I want you to pay attention to is the various different capacities. I have been contacted by Sylvester Moore Eel. That represents the private individual, right? And he's the private banker and trustee of the SDM, which is my initials, Private Bank and Trust. And he's the attorney in fact for Sylvester Dylan Moore, which is the organization or the estate that was created at birth, the straw man, the entity, the instrumentality of the United States that they use to interface with you, that they created, that organization. That organization, in my case, is Sylvester Dylan Moore. It's the name that was on my certificate of live birth. The notary saying she's been contacted by Sylvester Moore Eel, private banker and trustee for SDM Private Bank and Trust, attorney in fact for Sylvester Dylan Moore, doing business as Sylvester Dylan Moore. See the distinctions in these entities? Now if we were under the personal status correction menu, we would have already set up this private bank and trust tax ID number, and these different capacities that we point to would already exist in documentation. So again, this personal status correction menu goes through 4 steps of what we believe is necessary for personal status correction in commerce. Things like name and address correction, preparing certain documents, that may be held in your trust, like fee schedules, trademarks, property lists, memorandum of law. And then the third step is actually setting up the trust that controls the estate, which would include applying for the tax ID numbers, certifications of trust, and things of the such. And then the fourth and final step under there is the secured party creditor filing. That's the UCC filing with the private registered set-off bond that goes to the Treasury. But what I wanted to cross-reference here is, so we said Sylvester Moore Eel, private banker and trustee for, or private banker and trustee, what it was the whole title, Sylvester Moore Eel, private banker and trustee for SDM Private Bank and Trust, attorney in fact for Sylvester Dylan Moore. That's a private individual, right? Sylvester Moore Eel, at least as the entity that exists, that was created when I did the name correction, right? When I did the name correction, they gave me a court order and issued a new in legis, and it was named Sylvester Moore Eel. I gave it a nationality by publishing or a declaration of nationality. I added some color to it. Now that new in legis has a nationality. It's not going to rely on default residency to become a citizenship. So it has a private address, right? Because we set up the private mailbox. It has a private mailing location, a new in legis with the declaration of nationality. Well, that's the private individual or the private banker and trustee, or I may say he's also a native Ohioan, right? Being Ohio is the country where this private individual is from. If that's how you're going to do things, right? I'm saying that because some people say, I'm not an L or a Bay, and I don't know if I should change my name. I mean, there's a capacity, the state in which you were born is actually a country. So for me, I'm a native Ohioan in some capacity. But the point is, you see how this new private individual arises out of the estate per se. Everything, in my opinion, arises out of the estate. Private or public, it just arises out of the estate, especially if it relates to commerce per se. So now I also want to point out that under step 3.1, we have, this is where we apply for the tax ID numbers. And it was Patrick Devine that really brought the information about the private banker and trust tax ID number. Now, I don't really follow Patrick Devine, so don't say, well, Patrick does this like this and like that. How do you do it, right? But that was great research on his behalf. And when I looked at it, I got something out of it. I grasped something out of it, and it was very necessary. So I built on top of it to make what it was stronger, right? So I'm not, if you follow Patrick Devine, that's great. I don't follow Patrick Devine, so I'm just trying to cut down people saying, oh, somebody, he did it like this and you're doing it like that. Don't be confused. Do it the way that you think is best. But I talk you through everything I'm doing, right? So you can see my thought process and how we got there. But I wanted to point this out to you. Let's look at the PDF for the private banker and trust tax ID number. This is something you would have already did under personal status correction. First thing I want you to pay attention to is the legal name. This didn't just ask you for a name in box 1. It asked for the legal name. That's kind of equivalent to a trust registration statement. The trust registration statement, as I talked about in other videos, is the legal name for the trust. It's what matters most. When you register your LLC, corporation, or whatever with the Secretary of State, you are registering the legal name with them. And coincidentally, many states will not allow you to use the term trust or bank in your registration of a legal name for your entity with that estate. Because those names cannot be used by you registering an entity in the public. However, when we're registering this legal name with the IRS or the Treasury Department, we can say it's a private bank and trustee. And we know that this entity is private because you can't call an entity a private bank and trust in the public and register it in the public. And when we put it on this line, they give us a new tax ID number, so that's their form of acknowledging what was placed on the application. what we're applying for. So they're acknowledging the legal existence of the private individual when they give you a number for this application. But box 2 is quite interesting too, because box 2 asks for the trade name of the business if different from line 1. The trade name is different from the legal name. The legal name is the actual individual or owner per se. That's what I should have said, is the actual owner. In this case, it's the actual individual owner, because a private banker and trustee is a private individual. But the interesting thing is he uses the same name, John Alex Doe, as the individual corporation or the estate that was created at birth, which is an entirely separate entity. The one maybe you would say created by the government. This private individual uses the same trade name. So you may just see something with John Alex Doe in an address. You don't know whether that's the private individual banker and trustee, because as you see, he uses just that trade name. Or it may be the suretyship corporation that uses the social security number. It uses the same trade name. Or it might be the individual proprietorship, the sole proprietorship that has a different tax ID number and uses the trade name. Or it could be a foreign situs trust that has a different tax ID number and does different types of business, but is still authorized to use the trade name. So we're talking about capacity, just how we looked at Sylvester Moore Eel, private banker and trustee, for the estate of or doing business as whatever. So I just really wanted to point that out. And something else I want to point out, because somebody cursed me out, swore I was an agent. Let me tell you the story real quick. A brother named Chief something, I don't know, he does some foreclosures calls and stuff. Brother asked me to get him a tax ID number. He says, can you apply for a foreign situs, a 98 series tax ID number for me, because whatever, I think you can do it, or I could do it for myself, but I just want you to do it. I said, sure, brother, I'll do it for you. Charge you just a little bit to do it. And when I got ready to create the number, I was telling him I need this information for the application to create it. And I learned that he was one of these guys. Nothing wrong with you guys who look at doing things like that. He was trying to create a foreign situs tax ID number without using his social security number on the SS4 right here as the responsible party. And again, in my mind, just so you can see how this whole picture is connected, I would say the individual guarantee corporation, the suretyship corporation, that's how I identify the entity, the in legis that uses the social that was created at birth. Just so you can see the distinction from the private banker and trustee, right? There's a private banker and trustee, banking, private banker doing banking, but then you have a suretyship guarantee corporation insuring, doing insurance, signing with the general insurance policy, the 29, I was about to say my social, but the social. So is that making sense, what I'm trying to point out here? And since it's a general suretyship corporation, that is why I say it is the responsible party. It's the insurance. The insurer is the one responsible for the obligation. So obviously by the legal name, we could see this is private banking is the purpose of this. It's okay, in my opinion, to use the suretyship as the responsible party, because when they give you a new number for this private individual, it's clear that there's a separation between the responsible party and the private individual. Which one are you? Or maybe you are neither. Maybe it's just all about capacity. But the private individual, the private banker, is going to be doing the banker's acceptances, the bills of exchange, the discharging debts, the 1099s, and all of that. So he gets this new number with a separate capacity from the number that belongs to the entity that he's administering. So that private tax ID number arises out of the estate. And this is the estate. In my opinion, this is the estate that was created at birth. Right? Now, you might apply for a tax ID number to control that estate, but in general, if you didn't know anything about this and they said, give me your tax ID number, you would give them the social, which would then, I'm saying, represents the money. Not the money, the number for the estate. This is the first thing arising out of the estate as far as our administration, and that is the private banker's tax ID number. All right, I wanted to point that out because again, that's a cross-reference, and this private bankers and trust tax ID number that you get back in this box right here is going to be used on some 1099s. Other 1099s may use the General Suretyship Guarantee Corporation Social Security number. It's all about the capacity of what you're doing. If you're doing private banking, you're probably going to use the private banker's tax ID number, such as issuing a bill of exchange, doing a cancellation of debt. Well, I don't know. It depends. We're going to explain that because we're going to look at a 1099 INT and we're going to look at a 1099-C under this process, if you will. So there's your first cross-reference, which takes you back to the personal status correction menu. And that was for, as we see here, I have been contacted by Sylvester Moore L., private banker and trustee for SDM Private Bank and Trust, attorney in fact for Sylvester D. Moore L. So that's the capacity thing. One is a private individual, one is a public individual, and the notary is a notary public. So they're on the kind of like they're on the fence, so they can get the information in the jurisdiction as our agent. Now we get to the private banker's acceptance, which we've given to the notary. They've presented it. What I want to point out here, just basic stuff. What is this number right here? Sometimes people say, where does this number come from? Here we see SDM 0514 1981. I was born in 1979. The first commercial instrument, some call it a bond, would be SDM 0514 1979. That would be the number. That would represent my birth certificate. The first commercial instrument issued off of the estate created at birth. My SDM, my initials, my birthday, 0514 1979. And then if you're a secured party creditor, those who have their secured party documents recorded the right way, this first instrument after the certificate of live birth coming from your estate is going to be the next number. Like I was born in 79, so the next number is 80, which is going to be the master discharge indemnity bond or the private registered set-off bond, your bond that is on deposit with the United States Treasury based off your secured party creditor filing. So SDM 0514 1979 is the first bond issue, the certificate of live birth or the birth certificate, the original. And then SDM 0514 1980, secured party creditor bond. I'm not going to pull mine up here, but you'll see my bond that was recorded in 2012. That's the number on it. 1981, or it would represent the first banker's acceptance, promissory note, or whatever instrument is being issued off of that estate. So this is what that number is. It's a sequential number, and it's going to come after your secured party creditor master discharge private registered set-off bond. This is a draft. These are banking instructions except for the sum of, pay to the order of, deposit to, redeem in lawful money, charge to the account of. Charge to the account of, what am I talking about? That secret account at the Treasury. Except for it's really not a secret because we just said what it is. It's the account where your private discharge indemnity bond is being held. It can be tracked because you mailed it there registered mail. Here's the registered mail number. So here's my private bond. There's the number, 1980. We just talked about it. Here's the registered mail number. I'm identifying where this account is that I want to pull these funds from. It's recorded on such and such date, which you can find in the Maryland State Department of Taxation and Assessments. That's the UCC filing office. So I have the bond number, the registered number to prove it was delivered to the secretary. You can track where it's at, the date and time it was registered, and then under here is actually my UCC file number. So when you put your all rights reserved or without prejudice, you should put your secured party creditor file number because you're saying I'm reserving my rights under this security agreement because the interest and the proceeds have already been secured for anything that you want to securitize on this transaction. All right, so that's the instrument. And then once you tender that instrument via the notary, third-party witness, you have to capture that transaction because you just paid somebody. And actually, who paid them, right? Let's look at here on this 1099 INT. We see Sylvester D. Moore, and we see the private mailing address. So who is the payer in this transaction? Is it the general surety ship insurance company, Sylvester D. Moore, that uses the same trade name? Or is it the individual private banker and trustee, Sylvester D. Moore, who does a different type of business, has a different tax ID number, but also uses that same trade name? I will tell you, it is the private banker and trustee, because he issued a private banking instrument, right? Public individual can't issue this private banking instrument, and he had to send it through a notary agent because he's private. He's not in the public. So he sent the instrument through the notary. He used the red form, and he put his payer's tax ID number, which is the private banker and trust tax ID number that arises out of the estate, as the insurer or the guarantor responsible party. We just looked at that, right? So you should be tracking. And then the recipient's tax ID is the tax ID number to the people who you are discharging the debt with. Now, how do you get their tax ID number? It's very simple. It's really this simple. And me included, we can make it harder than what it is. What makes it harder than what it is when you try to do it any other way but the simple way. The simple way in this matter, and the reason why this is so hard for people is because usually nothing happens this easy in this game. You just simply call them, ask for their finance department, and tell them that you need the tax ID number. If they ask you why, just say my accountant said that I need it. Are you trying to fill out the I don't know, but I do need it because I do have an account with you. Here's the account number. So I need the tax ID number. And if you don't want to call them, fax them or email them a W-9, which is a request for a taxpayer ID number. And if you want to be quicker than that, you really don't even have to send the W-9. You could just send them a professional email and ask them to return for you their taxpayer ID number. And if you really have an account or business with them, they'll return it to you. I've never been denied it, right? Only if I really didn't have any type of business with them. Then maybe I could see a circumstance where they'll deny giving you the tax ID number. Anyway, that's how you get their tax ID. And it makes you wonder, why do they give this tax ID number up so easily? Because they want to fight you about everything else. And we're sure it's obviously because they have to. So if they have to give it up, that means the Treasury is forcing them to give it up. So it is probably likely that the Treasury, as they say, are going to expect to see this income on their tax return. That's why the Treasury wants the 1099 INT. On the other hand, if it was a 1099-C, the Treasury would expect to see the income on your return, or at least you would have to be the one to account for it. Again, none of this is tax or legal advice. It's just based off the fact of what I study. And I can show you references for why we arrived to these conclusions. Let me take a quick pause before we go through and finish. And I just want to say, please like the video if you like it. And schedule a coaching session or go ahead and create your yearly membership. It really does help. It helps me be able to peacefully put together the in-depth research so I can break this stuff down to you. And if you're a member of thttrust.org, I'm sure by now you can see the progression of what's being done. That's why, again, I'm cross-referencing and showing you why we set things up like this, because it's how we're going to have to do commerce moving forward. All right. So let's see. On here, they ask you for the account number, right? So you'll have the account number because you're going to need that account number to get their tax ID number. If they ask you, do you have an account with us? So that's that. And again, I said the payoff statement, those 4 documents are the first transaction. You send them to the CFO and you give him time to honor the transaction and adjust the accounts and zero out the account and send you a release of lien paper or satisfaction that the debt has been canceled. But if he doesn't adjust the record, then you can expect that he must be sending back your banker's draft because he found a defect in the instrument. At least maybe it's in the amount or the words or the date or the number or some defect in the instrument that makes it invalid, right? That's how he's going to dishonor it. I'm just joking because they're never going to send it back. I've never seen them send it back. But what I'm saying is that is what he's supposed to do. Send it back with the defect, or he has to present it to the Treasury or the Federal Reserve, the agent for the Treasury. He has to present it to his bank for payment so that they can say, there's no funds in the account or whatever, and they can give him the dishonor, and then he can return it because it was dishonored. But the point is, if he doesn't return the instrument and he doesn't show you evidence of dishonor for a bank, then he accepts the liability and he defaults on it, and your notary then must issue a protest. That's why you present it through the notary in the beginning, because the notary has firsthand knowledge. Now the notary can issue a certificate of protest, which is a discharge. It's actually evidence of the dishonor. It's a certificate of dishonor, but it also is a discharge when you look at the definitions of what the discharge is and how the IRS looks at a discharge, and you just look at the words of cancellations and discharge, and you see that the notary certificate of protest is actually a discharge. So let's go down there real quick. We've seen this already. We went over it in another video. But this certificate of dishonor or certificate of protest, when I say it's the discharge, let me further explain what I'm talking about. It's the account, right? The banker's draft was an account also for a certain amount of money, let's say $600,000. And that's why we brought the 1099 INT to report the transaction. Payment was made, an account was transferred for the sum of $600K or whatever. So we report that transaction. If they dishonor it and ignore it and they're not going to count it as their income, then my understanding is doing the protest is almost in itself a way of a redemption, because now you're pulling the account back. You gave it to them, you put it on their books, they didn't account for it, but you accounted for it. So now when the notary issues the protest, which is evidence of dishonor according to the UCC 3, it is evidence. Actually, it's not, it's evidence according to UCC 3505, right? But according to UCC 3, what is it? I want to say 605. No, UCC 3 605. Yeah, and 603, it actually is the discharge. So since it's the discharge, when the notary issues this certificate, it's just as much as a commercial instrument as your banker's draft. So it has the value of the discharge, and you run a 1099-C on that transaction, right? So what I'm saying is this notary certificate of protest, by definition in the UCC, is evidence of discharge, and it is a discharge. So when you look up what the IRS says about cancellations of debts and discharges, a 1099-C needs to be filed. And plus, I know members of thctrust.org, and I'm going to share this with you guys for watching. This is a nugget for everybody still listening, that myself and other gurus, as we have studied this 1099-C, a lot of us used to put ourselves in some capacity on the line as the creditor and put the people who we're discharging the debt with as the debtor. When people have finally figured out that, hey, in the capacity of discharging the debt, we need to be down here as the debtor. Your straw man should be there, and the creditor is the other party in the public who's holding the debt liability against you. Because when people started doing that, they started seeing more successes with these discharges. That's what I've personally been told by members. But let's look at something else that I just mentioned. We're talking about a cancellation of debt. Who's getting the debt canceled, right? So in this capacity, we're not going to use the private bank and trust tax ID number. We're going to use the General Suretyship Corporation, the debtor's tax ID number, right? Now, who's authorized to discharge debt? Most people researching the Form 1099-C has not read the instructions of the form, nor have they read the publications that go along with it. And that's why I'm here for you, because I've read this stuff. and I'm sharing with you and trying to point out what's most important. So please subscribe and hit that membership. Do it right now. Okay, but so let's get back on it. And what I want to pay you to pay attention to is this thing down here in box 6 on the 1099-C cancellation of debt. It's called an identifiable event code. What they're asking you for is one of, I want to say it's like eight different events of which authorizes a cancellation of debt in accounting or in their system of accounting, right? Coming straight from the IRS. So which one of these can you use? Because one of these you're supposed to use when, according to the creditor's policies and procedures, the debt is supposed to be discharged as a matter of collection. So basically what I'm saying, one of these requires, let's say, the lender to discharge the debt, to be the one to say, we're going to go ahead and write this off and discharge it. Meaning, under that specific identifiable event, you, as a private banker and trustee, cannot execute this form because you're in the debtor capacity in this transaction, not the creditor. Let's go look at what I'm talking about. Oh well, this was this was not what I was looking for, but let's see what this is. Okay, we were on the IRS official website here, and instructions for 1099A and C. Now I want to go down here to these event codes. It's a box of them. Where are the event codes? Okay, well here's the event codes. Why is this? I can't get this in the center of the screen here. When is a debt canceled? A debt is deemed canceled on the date an identified event code occurs. Wow, I didn't see that before. I mean, I seen it before, but that wasn't what was in my mind to show you. But do you see what that's saying? A debt is deemed canceled on the date an identifiable event code is used, or if earlier, the date of the actual discharge if you choose to file Form 1099-C for the year of the cancellation. So that's important. They just said this is the event code right here. So there's something going on as far as like tracking the discharge of debt in time. They're saying, when does it occur? So it's first in line, first in time when it comes with these event codes. This is why. Let's look at some of these event codes. A discharge in a bankruptcy or Title 11. Say you lose your property that type of way. Well, you enter box A. In that bankruptcy, of course, there will be a specific time when it occurred because it'll happen in court and everything will be date and time stamp. So whoever receives the property as the creditor under that transaction will probably do some form of a 1099-C against you, and they will fill out box A because they wrote off or discharged the debt, but in return they're taking your property. A cancellation or extinguishment making the debt unenforceable in a receivership, foreclosure, or similar federal bankruptcy. That's event code B. Once again, tracking the time of the cancellation of discharge or debt by the creditor, whoever it was that ran their administrative process against you and procured a judgment or some other official record of discharge. It's the same thing we do when we procure our private administrative process to get our notary certificate of protest. That's our process to get our event code so we can be the first in line to discharge the debt. Notice all of these things are asking for an official procedure: a bankruptcy, a receivership, a court order. A notary certificate of protest is an official seal, has an official seal on it. It's a record of evidence. It's a state record. It's a court record. Box 3, a cancellation extinguishment when the statute of limitations for collecting. Enter C. Number 4, extinguishment when the creditor elects foreclosure remedies. Right? So when your creditor says he's going to do a foreclosure remedy to recover that debt, he's going to, when he finishes it under like a power of sale, non-judicial foreclosure state, he uses box D. None of these says that your private banker and trustee can use any of these event codes yet, right? We're under 6 for the cancellation of debt event code. A discharge of indebtedness due to an agreement between the creditor and the debtor. Well, if your CFO or financial officer is in dishonor, you guys don't have an agreement, so you can't use F. A discharge of indebtedness because of a decision or defined policy of the creditor to discontinue collection activity and cancel the debt. That's them saying, okay, we're going to write it off, blah, blah, blah. That's event code G. You can't do it. Now, here's the last one. Other actual discharge before identifiable event. Enter H. So if there's a other identifiable discharge before any of these events that we just described above, then that person who discharged it, and it doesn't say their name has to be on the form. It didn't say that. The only people that's going to be on the form is the creditor and debtor on the account. But in this case, when we're looking at H, we're looking at the subrogee actually discharging the debt for the subrogor, if you look at it from an equity standpoint. The same name, Sylvester D. Moore, the general surety with the liability, but the private banker and trustee with the remedy. So that would be, again, event code H. If there is another actual discharge, that if you look up what the Uniform Commercial Code says, it says there is discharge under 3-505. That is actual discharge, right? Before any of the identifiable events above. You can always finish your administrative procedure before they finish theirs, because you can really knock it out in 72 hours if it was required to happen that way. Usually we give them 10 days to go and dishonor so that the notary can issue the certificate of protest. So this is the actual discharge, the 1099-C. And generally, and I'm saying generally because it's not always the case, you have to do your research. If this occurs, the debt will be discharged, but the IRS is going to be expecting the debtor organization to reflect that discharge as income unless it's otherwise exempt or whatever. I'm not here to give you tax advice because I can't give you tax advice, but I just study this stuff. You see what I'm saying? So now the discharge is complete at this point. 1099 INT, when you tender the banker's acceptance because you made a payment, but when it's dishonor and a protest is issued, there is discharge. So event code H on a 1099-C on the cancellation of debt document. And there's some more that we could say about that, but we're going to leave it at that for now. Now also, now you have your evidence. These same documents right here, if you had to go enforce, if the private banker or the subrogee had to make a dispute under an equitable under a bill of equitable relief for subrogation or something of the such, this is evidence of the payment. We just seen what the IRS said. It is deemed. I remember Yusuf L in high frequency radio. He talks about that word deemed. You should look it up. It is already done. It's done. So instead of arguing about the legitimacy of the debt, discharge it. So now if you have to find yourself in court, you're not the one arguing. They're the one arguing against what has been deemed to be done, right? And I hope you really enjoyed this video, because if you're a member of THCtrust.org, this is just one tool that we have here. You see how powerful it is, how concise and precise it is. So please, again, like the video. Feel free to share the video. Schedule a coaching session by clicking the link below the video. Or get yourself a yearly subscription so you can have access to all the templates. And what else? I'm available. So thank you for watching. Peace and love. I hope you enjoyed this.